right, no other questions.
Mr. Holy, anything further?
Nothing further, Judge. Thank you.
Okay, thank you, officer. You can step down. Watch your step. Let me give you all a little bit of a heads up time-wise. About 12:40, I got to leave to go to the doctor.
Yeah, Judge.
If you're not done by then, when I get back, we can finish. I shouldn't be down there that long, I hope. So use your time wisely. I just let you know.
Thank you, Judge. Judge, I don't have any further witnesses.
Okay. State, you want to present? I'm not preventing you from calling them. I'll give you time when I get back.
I only had one other subpoena. So
they're going to do one thing to me, supposedly.
And Judge, I don't know if Mr. Foley wants me to present this, or we can agree that Detective Kennedy is the one that personally observed the defendant. I can call him to put on the record.
I think we're probably going to do establish it.
I call Detective Kennedy.
Okay, you have him come in, please.
Our portion is closed. Thank you.
Okay, I'll give you as much time as you wish. Just use it wisely prior to 12:40. Officer, thanks for bearing with us. If I can just have you come right up here, I'll place you under oath. Raise your right hand, sir. Do you swear or affirm, sir, the testimony you're about to about to give should be the truth, the whole truth, nothing but the truth?
I do.
Okay, sir. Thank you. And just step right over here to your left, please. Watch your step. Miss Day, when you're ready.
Detective Kennedy, can you please state your name for the record and spell your last name?
Detective Garrett Kennedy, C-A-N-A-D-Y.
And where do you work?
City of Port St. Lucie Police Department.
How long have you been with the Port St. Lucie Police Department?
I just completed 12 years.
And what is your current position within the Port St. Lucie Police Department?
A detective in the Special Investigations Unit.
And back in March of 2009, were you also working in that same capacity?
Yes, ma'am.
I want to talk specifically about a search warrant that was conducted, and the date that the search warrant was signed was February 25th, 2009. It was based on a controlled delivery of cannabis that happened on February 18th, 2009. Were you involved in that controlled delivery of cannabis?
Yes, ma'am.
Okay. Can you tell the court what your particular involvement was in that case?
My involvement was to follow the CI to the resident on Avens. Watch the CI as he or she entered the resident, and after the CI left, to follow the CI back to the undisclosed location.
Okay.
I'm sorry. Speak up just a little bit. Follow him back to
Sorry?
You said follow him back to an undisclosed?
Back to the undisclosed location.
Okay. I just couldn't hear you. Okay.
And were you working with Gary Grenier on this case?
Yes, ma'am. Gary Grenier was the case agent.
Okay. And can you tell the court, I know that was your assigned role, but were you able to observe the confidential informant in this particular case? Were you able to maintain constant surveillance from the time he was searched to the time he went to that residence?
Yes, ma'am.
Okay. And did he stop anywhere else or come into contact with any other individuals during that time period?
As he was approaching the resident, there was another vehicle that was backing out. It was going south on Avens. Momentarily stopped. However, neither one of them got out of the car. There was nothing exchanged or anything.
Okay. So, did you have constant surveillance on him then from until he went to the home?
Yes, ma'am.
Okay. And can you tell the court where in the home he entered?
He entered inside the garage.
Okay. And did you also maintain surveillance on this confidential informant from the time he exited that garage until the time he went to this undisclosed location and was searched?
Yes, ma'am.
Okay. And again, did you notice any kind of exchanges or any, did you lose sight of him where he may have been able to obtain narcotics?
No, ma'am. When the confidential informant exited, the resident got into her vehicle and drove directly back to the undisclosed location. There was no contact made. It didn't stop. Didn't talk to nobody.
And did you relay your observations in maintaining that surveillance to the affiant, in this case, Detective Gary Grenier?
Yes, ma'am.
Okay. No other questions?
Mr. Oley.
You followed the CI on two separate occasions. Sorry, you followed the CI to Southwest Avens, correct, initially?
Yes, sir.
Okay. And you say that he met two people on the street?
I'm not sure if there was two people. As the CI was approaching the resident, there was a vehicle backing out of the resident, and he stopped down the road. After speaking with the CI had said, after we got back to the undisclosed location, the CI had said that it was somebody that he or she thought that he knew.
That wasn't disclosed in your report, was it?
I didn't do a report.
Okay. As you followed the CI to the location, were you aware that he had told Detective Vernier that he had been there the day before?
No, sir.
Okay. And how many times did he get lost?
Just that. I don't know. Remember the CI getting lost at all?
Really? Okay. You don't remember losing track of where he was going?
No, sir.
How close of a distance did you maintain to the CI as he approached 713 Southwest Davis Street?
Approximately maybe 3 to 4 car lengths.
And you would agree with me that the confidential informant's car did not have window tint?
I don't remember.
At what time did it become apparent to you that the listening device of your confidential informant had been removed by him?
I didn't know it until we got back to an undisclosed location. I wasn't monitoring CI.
So you would agree with me that he was able to somehow manipulate or take this device off without you seeing it?
Yes, sir.
And you didn't discover that until when?
I didn't know it until we got back to the undisclosed location after he left the Mr. Cobb's residence.
Don't you believe that to be a little bit problematic?
I'm sorry?
Problematic that he removed his listening device prior to going into this residence?
Well, a safety issue is one reason why.
What about a monitoring issue, the ability to corroborate the truthfulness or the veracity of this confidential informant? Would you believe that be significantly mitigated that he took this device off?
It's possible, but I'm believing that he took it off just because it was a safety issue. But it becomes a safety issue to us because we're not able to hear what's going on inside the residence. And if we can't hear, the CI gets himself or herself in trouble, we won't know anything about it. So it is a safety issue if they remove it.
But also a veracity issue. If you've never utilized a confidential before, how would you know he was telling the truth unless you had something to corroborate? Just his word, correct?
Yes, sir.
Hey, did you ever conduct any surveillance on the residence prior to the execution of the search warrant or after February 18th?
Prior to the day of the search warrant, we executed the search warrant. I did surveillance yesterday.
Did you ever...
Stay and redirect.
You mentioned that you did surveillance. Can you tell the court what you observed during your surveillance the day before?
I'm sorry?
Can you tell the court what you observed during your surveillance the day prior to the controlled delivery?
No, that's the day of the execution of the search warrant.
Okay, can you tell the court, you mentioned that you did surveillance prior to this, is that right?
No, ma'am. Just the day prior to the search warrant, not the day prior to the walk or whatever.
Oh, okay, prior to the search warrant. I understand. Another question.
Judge Oss, you never saw Cobb give the CI anything, correct?
No, sir.
And you never saw any money or anything transpire between the two of them?
No, sir.
And so when the CI walks out of Cobb's house and says, I got this from Cobb, we have no way to corroborate that or substantiate that, correct?
That's correct.
Other than his word?
Other than his word.
And he has never been utilized before, so his word is for what we take it, correct?
Other than his word, but the CI was searched prior to him going into the house, and when he came out of the house, he came out with drugs. And no, I did not see money exchange. No, I did not see drugs exchange.
And you never heard anything, correct? You never heard or saw
No, sir, I heard nothing.
Ms. Day, anything further?
No, sir.
Okay. Thank you, officer. You can step in. Watch your step. Ms. Day, do you have any other testimony you wish to present?
No, sir. We'll just that you take judicial notice of the court file.
Okay.
On that point, I made a mistake. The search warrant itself is here in the file, but I don't have the affidavit, so I may have to get y'all to make a...
The application, Judge?
Yeah, I've just got the warrant itself. But if y'all don't mind, I'll get somebody to make a copy.
Good man, brother.
Yes, sir.
All right.
copy. If you'll give it to Larry here, I'll have him make a copy. I just need that affidavit on
You
it.
can have that, but you can have
Got the warrant, but not the...
with the affidavit.
Mr. Oley, any argument you wish to make?
Yes, Judge. I don't know if Your Honor had the opportunity to review my motion.
Yes, sir.
But I'll be brief. I know Your Honor is pressed for time, but I do want to address all the issues. Judge, I think we got an inherently defective search warrant here, and the basis for that truly is the confidential informant or the confidential by exception does not apply here. We have a case involving no indicia of reliability, no prior use of the confidential informant, no use thereafter. And so that when he goes in the residence, and also another important tidbit which we discovered today, is that he removes his device. He removes his audio and listening device. And so that to say that the confidential by exception applies here, he has to be adequately monitored. And it's our position that he was not adequately supervised because he has no indicia of reliability. When he walks out of the residence and says, I got this from Cobb, well, that's all hearsay. That's all conjecture. That's all speculation. There's nothing to corroborate what he said. The detective never saw a hand-to-hand transaction. We got unusual activity with him meeting with two people prior to going in there. The detective testified clearly, Judge, that he never saw this individual remove his listening device. So I wonder how close was he maintaining a witness, or how close was he maintaining a supervisory position of Mr. Cobb's house and of the CI. I speculate not very well. I don't think they would allow this to transpire had they known that their confidential informant removed his listening device. Importantly, Judge, the lack of confidential informant reliability is really the crux of this case. It normally wouldn't be. We'd have a controlled buy, we'd have a controlled delivery. The lack of confidential informant reliability would not be an issue. But with respect to this case, it clearly is an issue, Judge, because without his reliability, without anything corroborating on video or audio, and all the odd things that are transpiring here, let's talk about this, Judge, that he had to be redirected, and I didn't have the deposition of Gary Vernier deposed, but he testified that it happened 3 separate times. At his deposition, he testified here that it happened 2 separate times.
So no one object to that statement.
I understand. And Judge,
any objection, that's not evidence. Okay.
But Judge, he got lost on 2 separate occasions, according to Detective Gary Vernier. If he was at the location the day before, how would he have to get lost? How would he get lost on 2 separate occasions? Detective Canday testified he doesn't remember the individual getting lost on any occasion, and he was the one maintaining a supervisory position. It's alleged by the affiant in this case is the one who really made the allegations, and he clearly states that he got lost on a couple occasions, whether it was night, whether it was day. Judge, he was there the day before. It goes to his truthfulness, it goes to his veracity, that he didn't see these items. Now let's talk about the items. I know it's after the fact, but we don't have the items as listed. We don't have the 40 to 60 pounds. We don't have the gun. We don't have any oxys or any roxys. We don't have the bagging devices. We don't have the scales to substantiate this. What do we got? We got a confidential informant who has no indicia of reliability, who exits the residence. And Judge, based upon the totality of the circumstances, I believe that this case hinges on is that his lack of indicia of reliability carries forward into when he says, I got this from Cobb. Well, where did you get it from? Can we prove that? No, we can't. Judge, I had some cases here that I wanted to go over with, and I'll be brief. State versus Solomon, it's before the 4th District Court held that while a confidential informant's controlled drug buy alone may be sufficient to establish probable cause for a search warrant, the trial court must determine whether the nature of the controlled buy indicates the informant was sufficiently supervised and monitored to indicate probable liability of the information obtained by the informant. And Judge, that is the crux of this case. He was not sufficiently monitored. He was not sufficiently supervised. And so there's no indication that we were going to get any drugs from Cobb's house. We're going to get any drugs from Cobb because we don't know where they even came from if we look at the indicia of reliability with respect to him. He's never been used before. Unlike State versus Solomon, in this instant case, we lack any statements from the defendant and any audio or video corroboration of the CI's observations. State versus Solomon had that. In fact, State versus Solomon had, hey, come back next week for something else, meaning that a transaction took place and you can get more back at this location. This case doesn't have that, Judge. State versus Grisky, Judge, 328 Southern 2nd, 16. Old case, Florida Supreme Court case from 1976, just a couple of years after I was born, where reliability of the confidential informant is necessary when the affidavit is relying on hearsay statements to establish facts. And Judge, although the confidential by exception came thereafter, this premise still reigns true, is that we must have some indicia of reliability for that affidavit to have any credibility. And here it's clearly lacking, Judge. McCall versus State, 684 Southern 2nd, 260. The 4th District held that the trial court must determine whether the nature of the controlled by indicates that the informant was sufficiently supervised and monitored to indicate probable reliability of information obtained. Judge, that's a case out of the 4th DCA, and they held the trial court properly utilized its discretion in determining that the control by exception was inapplicable to the facts of that case because the CI was not searched prior to the control by. And I'm not saying that happened in this case. We had testimony from the officer that they were searched. But then we had something odd, come up with the fact that we saw a vehicle back up and this defendant, this confidential informant may or may not have contact with them. But Judge, I think we look at the totality of the circumstances here, which is clearly the law, that this is really a defective warrant. Garcia versus State, 872 Southern 2nd, 326. That was a 2004 case. And Judge, that case, it was found the police did not have sufficient probable cause to believe cocaine we found in the defendant's home to justify a search warrant, as the facts surrounding the search warrant regarding the reliability of the CI were controverted at a hearing on the motion to suppress, which I believe they were done here. No officer witnessed informant's first meeting with the defendant. Again, that happened here. And a subsequent buy that occurred at a parking lot was not maintained by constant visual surveillance from the time the defendant left his house. Judge, we got a situation here was not maintained by visual surveillance. He goes into the house, we don't hear anything else, we don't see anything else. District Court of Appeal noted that first the affidavit failed to mention the CI was working for the affiant. Again, in this case, we don't know whether he was working in lieu of charges, and that should have been placed on the warrant, and he was in fact working in lieu of charges. And Detective Grenier doesn't believe there's an issue with regarding their truthfulness or veracity, but that's not what the case law states, that in lieu of charges does mean there's an issue regarding truthfulness or veracity. In fact, it was the CI's first and only encounter as a CI for the informant, for the affiant, which required him to be directed by law enforcement on three separate occasions. I'm sorry, in this statement it was 2 separate occasions testified by Gary Grenier. Additionally, the police were not present or monitoring when the CI was allegedly legally inside the residence. Happened in State versus Garcia. The confidential informant allegedly goes there on February 17th, was not monitored by law enforcement. They weren't even present. In the absence of the affiant's knowledge of the CI's past proven reliability, the statements were mere hearsay and should have not been utilized. And what I point out, Judge, is most notably paragraphs B, C, and H, which form most of the basis of the application for the search warrant, are complete hearsay in the absence of any past proven reliability of the CI. I think under the totality of the circumstances, we have even more than that. We have a CI removing his audio and monitoring listening device. We've got circumstances here that rise to the level of serious speculation, which should have been included in the application for the search warrant. And most particularly whether he was working in lieu of charges and whether he had removed his audio device, because we have nothing but mere hearsay to rely on, Judge, and that's not enough to secure the entry into one's home. The sanctity of one's home is safeguarded by our United States Constitution as one of the utmost principles of our law. And Judge, I think in this case it was violated, and it was violated in a fashion that this confidential informant was not reliable, and it should have never formed the basis for a warrant. And Judge, we're asking that you suppress all the evidence thereafter. Thank you.
Thank you, Ms. Daya. You got about 15 minutes or less, so if you're not done in 10 or 15 minutes, you're going to have to come back this afternoon.
That's fine, Judge. I'll try to make it quick.
Bradley is the soul of wit, and I think somebody said, all right, go ahead, almost.
Okay. I think that the tester, I think we're in agreement that the real issue here is obviously one control by is enough for a search warrant, so I'm not going to address the case law on that. But specifically, I think the issue here was, as Mr. Rowling said, was this a control by? Was there enough safeguards in place? And I think that, obviously, yes, would it have been fabulous if we had a recording of when the confidential informant went inside the house, and we could play that today in court, in which he's making statements like, yeah, come back next week, I'll give you 50 more grams of cannabis. That would be great, but we don't have that here. What we do have, though, is officers maintaining constant surveillance on a confidential informant who was searched. Not only his person was searched, his vehicle was searched prior to entering a home. There was constant surveillance maintained on that individual. There are no other transactions made with any other person. He goes inside the home. He comes out with 53 grams of cannabis when he leaves the home. He is again, constant surveillance is maintained on that individual, and he is searched at a later time. So the evidence is clear, both in that search warrant and today on that witness stand from both Detective Kennedy and Detective Grenier, that there was drugs inside that home, as evidenced by this individual going inside the home without drugs and coming out with drugs. And that formed the basis for the PCMS search warrant. As far as some of the cases that defense presents to the court, the state's argument is that the confidential informant in this case was monitored sufficiently enough, and I think this would be a completely different case if there had not been an adequate search done, if there was not constant surveillance maintained. We wouldn't even be here today, because I would agree that there is no probable cause, because there was gaps in the chain that between when this confidential informant was searched and when these drugs were maintained. But because of the facts being what they are, I think that there's been no other testimony that there was any other place that this marijuana could have come from based on the testimony of these officers. Also, in the case McCall versus State, this case specifically talks about, and this is on the page, the last page of it, that the determination of whether the controlled by exception should apply and the adequacy of the police officer's search, supervision, and control of the informant or matters within the sound discretion of the reviewing magistrate. I asked Detective Grenier some questions about what judge he took it to. He indicated he took it to Judge Ikuchi, who in this case would be the reviewing magistrate. He reviewed the probable cause affidavit, and after reviewing that, and I asked him, did he read it in your presence? It wasn't like he just signed off on it. He did read it. He did take that into account, and in this case, he found that that was enough to issue the search warrant. And I'd allege also that the testimony here today also shows that, and that's to be given great deference by Your Honor as the trial court in this case. And I did have some cases. First case, this is State versus Evans, 692 Southern 2nd, 216. It is a 4th District case. Basically, I'm presenting this case. It wasn't really argued, but that the fellow officer rule does apply to search warrants, just as in any other type of case. So even here, where Gary Grenier did not personally maintain the constant surveillance on the CI, his partner or the other detective on scene, Detective Kennedy, did observe that. So that's the reason I'm submitting that case. Also, this is a recent case. Unfortunately, I don't know where my copy went. Do you have a copy? The site is State of Florida versus Savorin, S-A-V-O-U-R-I-N. It's a brand new case. It's 2010 WL Westlaw 2472273. It's a 1st District case. I'll get the court a copy of it. I only have one for the
Or give me
Oh, I forget it. This is for the proposition that even if the search warrant is technically flawed, which I'm alleging that, I'm arguing that it's not. I'm arguing that there's probable cause within that search warrant, that the reviewing magistrate made a right decision when he signed that. But even if there wasn't, the state would be asserting that the good faith exception would apply in this particular case. In this particular case, the detective submitted the affidavit to Assistant State Attorney, who approved it, which was similar in this case. They then submitted it to a judge who looked at the warrant and then approved it. And again, there's testimony that not only did the judge sign it, but the judge read it and didn't just sign off on it. And I would suggest that under this case, and there's several other cases on point for the good faith exception, that that the search warrant, there was probable cause within that search warrant, and the defendant's motion should be denied.
Thank you, Mr. Foley. I'll give you a couple of minutes to respond.
I'll be just brief and rebuttal. I just wanted to point out just the 2 of the cases that I've looked at those briefly. But first case is right here, Judge State versus Evans. And the reason why I say this is not, I think it does not apply, it's inapplicable. It involves what's called a concerned citizen, a citizen informant, which is drastically different than a confidential informant. And so I think that case is inapplicable. And just in, dealing in motions to suppress, and all these cases are so factually intensive that to even bring a case that talks about this, I think, Judge, is just not relevant. Because we need to talk about confidential informants, not people that have preset indicia of reliability. So that would be my argument with respect to State versus Evans. It's just inapplicable because it just doesn't deal with concern on a confidential informant. Next case, State versus Suborn. I argue that this is not really relevant, Judge. It's a factually intensive, and the reason why I say this, I think it's just not germane to the issue that we're dealing with. Judge, we're talking about sexual performance of a child. The cases that I provided are all search warrant cases, and I think that these cases are just a little bit out in left field. That when we're dealing with search warrants, is we're dealing with confidential informants, that there's been so many carved out exceptions that we must look at really those cases and the totality of the circumstances of the facts, and then apply those facts to the law. And I think that's why I'd argue that these cases are just not applicable, Judge. They don't deal with the issues that we've discussed. And Judge, it really comes down to lack of supervision. He was not properly supervised, Judge. I think the officer didn't even know when he removed his listening device. If he didn't know when he removed his listening device, how could he properly be supervised? He met with two odd individuals as he was driving to the defendant's home. He doesn't know what the gist of that conversation was. Under the totality of the circumstances, Judge, everything that was in that search warrant, the application for the search warrant, is inadmissible hearsay. And had Judge Ikuchi had been privy to that information, that the confidential informant was working in lieu of charges, had never been utilized before, and had removed his listening and audio device prior to entering the residence, I don't think we'd be here.
Okay. Is the ruling on this dispositive?
It is, Judge. Meaning that dispositive meaning, I think the state, our case would be over with respect to the state, but I think if it wasn't granted, I think Mr. Cobb was going to exert his right to go to a trial.
He is or is not?
He is.
So it's not dispositive?
Well, not. Yes and no, but yes, not dispositive, I guess, truly. If it was granted, it would be dispositive, but if it was denied, then it would lead to trial, so.
Okay, so it's not dispositive?
Correct.
Okay. All right, well, I'll take a look at this. I'm not sure I'm going to get all this done by Monday morning, though.
I understand.
Okay, I'll start working on read each case cited by the Evans case I'm familiar with. The other ones I'll take a look at before I make a decision, okay?
Sure. Judge, you have all the case law provided?
Yes, sir. Well, if I don't, I got the sites in your motion.
Thanks, Judge.
Okay.
Peter, Judge, I had a little conflict. That's why
I talked to I was in Indian River County. I talked to Judge Morgan this morning. I told him you could go up there because we've got this, what's his name? Davis case, so I don't think we're going to get to Mr. Cobb.
Okay.
But I'm not sure I'll have the decision on this motion done by Monday.
I understand, Judge.
Mr. Cobb, I need you here Monday so I can tell you when your next court date is. Mr. Oley, you can go to Indian River County.
Thank you, Judge.
Okay. But come here Monday, sir, so I can give you a court date.
At my original court time?
Yes, sir.
Okay.
Okay?
Yes, sir.
8:30 Monday here.
Thank you, Judge.
Okay, but Mr. Oley may not be here because he's got to go to Indian River County.
Okay.
All I'm going to do is make sure you show up and probably give you your court date so I can get this done.
Okay.
Okay?
Sure you can't keep me here?
It's up to you.
No, I'll see you again in River Monday. Thank you.
Okay. All right, just be careful what you ask for, Mr. Oley.
I know, Judge. I get it.
All right, I got to run down here. I'll be back. We'll go off the record till Monday.
Thank you.